Hi, hi, welcome back to my channel. So we will continue from where we left off. Excuse. Bankruptcy of natural persons provided for under Part 3 of the Insolvency Act. When does bankruptcy occur? Section 13 says, Section 13 says, what's that mean? Section Section 13 says bankruptcy occurs when the court makes an order in respect of a debtor adjudging the debtor bankrupt on the application of one or more creditors of the debtor, on the application of the debtor made in accordance with Section 32. If a person is adjudged bankrupt, the property of the person rests in the bankruptcy trustee, or if there is no bankruptcy trustee, the official receiver. Okay, so when it comes to insolvency of companies, an insolvency practitioner is normally the one that sequesters the assets of the company in order to distribute them. This for the administrator. But in the case of bankruptcy of natural persons, it's the bankruptcy trustee. Or if there's none, the official receiver himself. The person becomes restricted as to the business activities that he can undertake, and the official receiver is entitled to recover assets that the person has transferred within the 2 years immediately preceding the bankruptcy. Okay, so proceedings, we said under Section 17, bankruptcy applications by creditors. A creditor may apply for bankruptcy order in respect of a debtor. One or more creditors of a debtor may make an application to the court for bankruptcy order to be made in respect of the debtor in relation to a debt or debts owed by the debtor to the creditor or creditors. Such an application may be made in relation to a debt or debts owed by the debtor only if at the time the application is made the amount of the debt or the aggregate amount is equal or exceeds the bankruptcy level. And we said the bankruptcy level is 250,000 shillings and above. The debt is for liquidated amount, so there must be a specific amount in form of money. There's a number you can put to it. And is unsecured, and the date for each of the dates is a date that the debtor appears either to be unable to pay or to have no reasonable prospect of being able to pay. So that debt cannot be paid, and there is no outstanding application to set aside a statutory demand in respect of the debt. So what determines if a debtor is not able to pay? So for the purpose of this ascertainment, a debtor appears to be unable to pay only if the debt payable immediately, and either the applicant's creditor to whom the debt is owed has served a demand requiring the debtor to pay the debt or to secure compound for it. At least 21 days have elapsed. So the requirement for statutory demand is the same as the one for companies, like in the case of was it Rekik Sigis, if I decide. Case of Rekik Sigis, the case of Rekik Sigis stores, and in it's the case of Rekik Sigis stores. We also have the case of that is the main case. So now it's the same thing here. When it's a natural person, the creditor must have issued a statutory demand or a statutory notice that will and wait for at least 21 days before the before he proceeds. Okay. Okay, or execution or other process issued in respect of the debt on a judgment or order of any court in favor of the applicant or one of or more of the applicant to whom the debt is owed has been returned unsatisfied. So it's the same thing. Like in companies, we looked at two ways. We looked at where where the notice or demand is served and 21 days have lapsed and it's not fulfilled. And then we looked at the other way where the company is a judgment debtor and the decree is not executed, returns unsatisfied. Then we looked at the case of High Class Limited. Sorry, it was the Valuable General Agencies. We also looked at the case of Valuable General Agencies and the case, remember that case of the hotels, the Pride in Hotels versus, was it Pride in Hotels? Yeah, it was the Pride in Hotel. Not Pride, sorry, it wasn't Pride in Hotels. The Inri of Abadia Steel and Hardware Limited. Then, that was the one. The case of Mayfair, and Brunei was statutory notice. Okay, so okay. Now, so that's basically it. 21 days have to elapse. The execution unsatisfied decree and yeah. Okay, so that was section 13, section 13, 17. Now, let's look at this application of the data himself in section 32, where the data can make, when data may make application for bankruptcy order, a data may make an application to the court for an order adjudging the debtor bankrupt only on the grounds that the debtor is unable to pay the debtor's debts. The court may decline an application if it's not accompanied by a statement of financial position containing particulars of debtors' creditors and debtors' debts and other liabilities and assets may be prescribed by the insolvency regulations, or such other information as may be so prescribed. Okay. Okay, is that alright? So basically that is what happens where the data, when the data has seen that is and he cannot pay his debts, he will apply to the court and for to be declared bankrupt, but he must provide a statement of his finances showing his creditors and their other liabilities and assets and any other information required. The court may reject the statement of financial position if it is incorrect or incomplete, and this person who makes an application shall publish a notice in a newspaper and in other publications. Excuse me. The court may decline to hear the application if it's not advertised. Okay. Now, the court may refuse to adjudge a debtor bankrupt if Section 25(2), the applicant creditor has not satisfied the requirements in creditor's application. And we say the requirement in Section 17 is that he should have issued a notice, a statutory demand, and wait for the lapse of 21 days before he issues the whatever, before he proceeds to apply. Now, Section 25(2)(a), the applicant creditor has not satisfied the requirement and the debtor is able to pay the debtor's debt, or it is just unequitable that the court should not make a bankruptcy order. Now, what are the alternatives to bankruptcy? The alternatives to bankruptcy under Section 14 include enter into a voluntary arrangement in accordance, okay, make a proposal to creditors, pay creditors in installments, enter the no-asset procedure, okay. So under section 14, these are requirements alternatives to bankruptcy. They include a voluntary arrangement, which we will look at. Let's just look at it. This is division 1 of part 4, division 2, division 3, division 4. Let's look. Okay, division 1. Part 4. Okay, so division 1. Okay, so division 1, voluntary arrangement in relation to a debtor means a proposal that has taken effect when application for interim order can be made, an application to the court for an interim order may be made if the debtor intends to make a proposal to the debtor's creditors. Wait. Okay, I think we will come to that because it's taking all our time. Okay, so let's move on now. Who is entitled to make a bankruptcy application? Section 14. A bankruptcy application may be made to the court in accordance with the provisions of this part by one of the person's creditors or jointly by two or more of them. So by one of the person's creditors or by all of them, by the debtor or by the supervisor of any person who is for the time being bound by a voluntary arrangement. Now, court may make a bankruptcy order on application. On the hearing of such an application, the court may, subject to and in accordance with the provisions of this part, make a bankruptcy order. Effect of a bankruptcy order: if a person is adjudged bankrupt, the property of the person vests in the bankruptcy trustee, or if there is no bankruptcy trustee, the official receiver. So that is the effect. A person becomes restricted, they cannot conduct certain business. The official receiver is entitled to recover assets that the person has transferred within the 2 years immediately before bankruptcy. Okay. Proceedings on a bankruptcy application. Section 16. A bankruptcy application may not be withdrawn without the approval of the court. The court has a general power to dismiss or stay proceedings in a bankruptcy application where the insolvency rules have not been complied with. Now, creditor's bankruptcy application. Creditor may apply for bankruptcy order in respect of debtor. We saw this on application by section 17. One or two or more creditors may make an application for bankruptcy order to be made in relation to a debt or debts owed by the debtor to the creditor or creditors, and the conditions that must be fulfilled in a creditor's application include: an application may be made only if the amount of the debt is equal to or proceeds or exceeds the bankruptcy level, which was 250,000, and that the debt is for a specified amount, and that and the debt is a debt that the debtor is unable to pay, and the debt also should be unsecured. Okay, and the debt is a debt that the debtor cannot pay. So those are conditions. And there is no outstanding application to set aside a statutory demand in respect of the debt. Okay, so the debt is not disputed. Okay, expedited creditor's application. Statutory demand means a demand for payment of a debt made by a creditor. Okay. So expedited creditors application. A statutory demand means a demand for payment of debt made by a creditor to whom the debt is owed at least 21 days ought to have lapsed since the demand was served and the demand has neither been complied with nor set aside. Section 19. When a creditor's application is made in respect of a debt that is the subject of a demand, the application may be made before the end of 21-day period referred to in section 17 if there is a serious possibility that the value of a debtor's property will be reduced during that period. The application contains a statement to that effect. So if the creditor fears that the value, the value of the property will be reduced, as he waits for 21 days to lapse, he can move before 21. A court may make a bankruptcy order on a creditor's application only if Section 20 it is satisfied that the date in respect of which the application was made is a date that was payable on the date of the application and it has neither been paid nor secured. That is one of the conditions we mentioned in section 17 that a creditor can only make after fulfilling the conditions. The amount must exceed bankruptcy level of 250,000 and also one of the debts should be unsecured. Now, under section 20, where the court is satisfied that the debt was payable and it was not paid or secured or compounded. This compounded, I don't know what it means. It's just check. Compounding a debt refers to the making of an agreement between the debtor and creditor, whereby an alternative obligation is incurred in lieu or in satisfaction of the debt. So this is an alternative payment arrangement where a specific performance of an obligation can count as satisfaction of a debt. Let me just take examples. Okay, there are so many meanings of the same term. Okay, let's move on. Now, a debt that the debtor has no reasonable prospect of being able to pay when it falls due. Now, section 20 is that section which now explains that the court can only grant. So these are grounds if not fulfilled, the application may be denied. One we saw was that the debt should be the debt should not have been paid or secured or compounded, that the debtor has no reasonable prospect of being able to pay. So the first condition is that the debt itself was payable and it wasn't paid, And the second is there's no reasonable prospect. So the first one is if the creditor issues a demand and there's a lapse of 21 days and he doesn't pay, then that is the first condition is fulfilled. The debt was payable and not paid. And the second is whether he has a prospect of being able to pay, that is future. Does he show any signs and symptoms, of being able to pay? Has he maybe told the creditor, I will pay maybe, that I plan to pay? So there's that communication, which if not there, the creditor can just, the court can grant the power, so can grant the bankruptcy order. So there's the prospect and there's the inability. Okay. So a debtor appears to have no reasonable prospect under Section 17 of paying when the applicant has served a demand requiring the debtor to establish to the satisfaction of the creditor that there is a reasonable prospect that the debtor will be able to pay the debt, and 21 days have lapsed since the demand, and the demand has neither complied or set aside. So where the creditor, okay, tries to issue a demand requiring the debtor to communicate and establish whether there is a reasonable prospect that he will pay. And the first one, where he is unable to pay, is where the creditor has served a demand requiring the debtor to pay or secure the amount, and at least 21 days have elapsed since the demand and it's not been satisfied or set aside. Now, also, you need to know that that is not only the test, like in the companies, there's the test of unsatisfaction or the unexecuted or unsatisfied decree, okay, in case of suits, and the person is a judgment debtor. We move on now. Oh, Now, at least 21 days have elapsed since the service of the relevant statutory demand, where a debtor is the subject of a statutory demand. Now, the court may dismiss a creditor's application when it is satisfied that the debtor is able to pay all his debt. Now, in the contrary, where the debtor is able to pay his debts, okay, all his debts, or has made an offer to secure or compound for a debt, the offer has been unreasonably refused by the creditor, then the order will not be granted. The order will not be granted. So where the debtor is able to make an offer to secure or compound the debt, and the creditor refuses it unreasonably, and the acceptance of the offer would mean that would entitle or would require the dismissal of the application, the court will not grant. Now, creditor who has made an application for bankruptcy order may not issue an execution process against the debt in respect of the property to recover a date on which the application is based. Okay, and he also may not continue with the execution process if the creditor has already issued the execution process. Okay, so you cannot continue the execution process, and I think by execution process they mean any attempt at possessing the debtor's property or attaching it to try and recover, to try and maybe exercise the power to sell, or just so you could recover your debt. Okay, so once you make an application, any efforts you are exercising prior to that moment needs to stop, so you can allow for the bankruptcy process to take place and maybe for an insolvency practitioner to be appointed so they can sequester the property. Okay, now if you proceed with the execution despite making your application, then whatever action you have taken is void. Okay, now creditor may make an application to the court for approval to issue or continue the execution process. A creditor can make an application for approval to continue. So where you feel you need to continue the process, despite the application, you can seek the approval of the court, because you see, if you proceed as a single creditor without the approval, the other creditors who need their debts to be paid might suffer, because you go ahead and execute and use whatever property, and there's no order of priority, like you're going to mess with the entire balance. So creditor may make an application for approval if he wishes to continue. Now, on the hearing of the application, the court may make an order permitting the creditor to begin or continue the execution. Such an order will only be made where the court is satisfied that the interests of other creditors will not be affected negatively. Now, after a creditor's application, a debtor or any creditor may make an application to court for an order to issue to stop the issuance of execution or to stop the continuance. Now, Section 222, on the hearing of an applicant, the court may make an order staying the execution process on terms and conditions, or allows the execution to continue on terms and conditions. Appointment of interim trustee of debtor's property on application of credit. Section 36 says that Section 36 says after a creditor's application has made, the creditor may apply to court for an order for appointment of authorized insolvency practitioner. Okay, so the creditor will make an order to appoint the insolvency practitioner who will sequester the assets and the property of the debtor, okay, and distribute them. Can sell any perishable property. Can take control of the property, sell any perishable property that is subject to decline in value, control the affairs or property of the debtor as directed by the court. So whatever that needs to happen happens through the insolvency practitioner through an authorization order by the court granted to a licensed insolvency practitioner. Remember, we had said that there's a consequence for acting without authorization, and that is payment of a fine not less than, not more, not less. Let me just say, not more, I think. Yeah, not more than 5 million shillings. That is section 5. So you need an authorization by the court. Okay, you need an authorization by the court. If you don't get it, you can be liable to pay a fine not more than 5 million. Okay. Now, moving on to debtors' bankruptcy applications. Now, this was under section 32, where the debtor applies for bankruptcy by himself. A ground upon which a debtor may make an application under section 32 is where it is made on the grounds that the debtor is unable to pay his debts. A joint application can be made by 2 or more debtors who are partners in a business partnership may make a joint debtors application to be adjudged bankrupt. And remember, the conditions for this under section 32 was that the applicant debtor must supply the court with any information required to prove his inability to pay, including the statement of financial position showing his liabilities and the creditors, okay. And where he fails to submit that financial statement is ground for the rejection of application, of the order of bankruptcy. Okay. Section 32(3), the court may reject the debtor's financial statement if it is incomplete or missing some or incorrect. Now, section 32(4) and 5, a debtor has not published a notice of the application in a newspaper. Oh, so we shouldn't forget that the the debtor needs to advertise his application in a newspaper, okay. On hearing of debtors' application, the court may make a bankruptcy order if it appears that Section 33, the total amount of debts is less than the small bankruptcy's level. Wait. Oh yeah, the court may not make a bankruptcy order because this is shocking me. I remember under Section 17, the requirement of application was that the debt must exceed the minimum bankruptcy level, which was 250,000 shillings now. So the court can refuse to decline, can decline to give the order adjudging somebody bankrupt, where under Section 33, the total amount of debt is less than 250,000 shillings. The value of the bankrupt estate is equal to or more than the prescribed minimal value during the 5 years immediately preceding the debtor's application. The debtor has neither been adjudged bankrupt nor made a composition with the debtor's creditors in satisfaction of the debtor's debts. Or a scheme of arrangement of the debtor's financial affairs. I think this is somehow like an extortion doctrine that, let's just see, though I don't want to speculate now. If the bankruptcy order were made, the value of the bankruptcy estate would be equal to or more than the prescribed minimal value. That during the that during the 5 years immediately preceding the debtor's application, the debtor has neither been adjudged bankrupt nor made a composition with the debtor's creditors in satisfaction of the debt or some scheme of arrangement, and where it thinks it will be appropriate to appoint an insolvency practitioner to prepare a report. Okay, so it means that where the court will look at whether the debtor had any arrangements 5 years prior to the application. So it's like you need to exhaust that arrangement first, the alternative, before you make your application of bankruptcy. Now, if you haven't, then instead of a bankruptcy order, the court will issue an order and appoint an insolvency practitioner to inquire into your financial affairs and submit a report, and where there is where he is of the opinion that a voluntary arrangement is possible between the creditors and the debtor to settle the debts, okay, then he will convene that meeting, okay. So there's some kind of exhaustion doctrine there going on here. Now, adjudication of bankruptcy applications. When does bankruptcy commence? Section 41. A bankruptcy under the Act commences on the date and at the time when a bankruptcy order is made in respect of the debtor. So that is Section 41. It starts when the date and time when an order is being made in respect of the debtor. Okay, and that date and time shall be recorded by the court. Okay. Okay. So yeah, so that is when it starts, just when that order is given, and the court will record the time and date. Registrar of the court to notify official receiver of bankruptcy order. So the registrar of the court will move in section 43 and make the notification as soon as practicable after the order has been made. Official receiver shall then nominate bankruptcy trustee. Remember, we said that when it comes to companies, the insolvency practitioner comes in. When it comes to natural persons, the bankruptcy trustee is also an insolvency practitioner, but the term will be bankruptcy trustee, the capacity in which he will move in respect of the property, okay? Because now all the properties will vest in the insolvency practitioner, making him a trustee, so he will move and act, sell, control on behalf of the debtor. Now, just a minute, I'll be back. Excuse me. So now, sorry, where are we? Yes, we were saying that there are certain conditions that must be fulfilled by Section 32 when a debtor is preparing the application for a bankruptcy order. Okay, they must be unable to pay their debts and must submit a financial statement, a statement of financial position showing the liabilities as well as the assets and the creditors, and also must publish a notice in the newspaper. Okay. And the court may refuse to grant the order where it has seen that the the amount of the debt is less than the small bankruptcy's level, okay, which is 250,000. So these requirements are both for when the creditor applies and when the debtor applies for himself. The bankruptcy level requirement of 250,000 and the exhaustion doctrine of whether in the last 5 years the debtor went into any scheme of arrangement with the creditors. Okay, and if that is not the case, in Section 34, then the court will appoint an insolvency practitioner to inquire into the debtor's affairs and see whether he is willing to come to terms with his creditors and arrange for some way to pay, and if so, he will convene a meeting. Now, where we say the bankruptcy commences when the order is given, and the court will record the date and time, and where the debtor applies, the official receiver will record date and time, and the registrar of the court will notify the official receiver of the order as soon as possible, and the official receiver shall nominate a bankruptcy trustee who will now be the what do you call it? Who will now be the one to sequester the debtor's property, and sequestering, we said, was to take possession, okay, of the property. So he will sequester the property and it will vest in him. Okay. Now, bankruptcy order to be binding, and remember the consequence of a bankruptcy order we said was restrictive on the business that the debtor can conduct. It restricts business. It also recovers property disposed of by him in the last 2 years, and also it what did we say was the other consequence? I forgot. Mm, Wow. How can I forget like this? No. I'm laughing because ah, I'm laughing because it's funny how you can forget in just a few minutes. Am I not drinking enough water? Maybe let me just drink. Yeah, I forgot the other consequence. Yeah, the property vests in the, if I'm not wrong, the property of the debtor, all the properties vest in the official, sorry, in the insolvency practitioner or bankruptcy trustee. Now, we say that the bankruptcy order is binding on the bankrupt and all other persons. Section 46, it becomes binding on the bankrupt and all other persons on the expiry of the time within which an appeal may be lodged against the order, or if an appeal is lodged in respect of the order within that period. Let's look at this section 46. Yeah, so it will be binding on all persons. Yeah. So what happens? Oh yeah, the official receiver under section 47 will maintain a register of all undischarged bankrupts. Okay. And what happens on and after bankruptcy commences? Recap. Uh, Section 41 bankruptcy under the Act commences on the date and time when a bankruptcy order is made. Effect of a bankruptcy order, Section 48. All proceedings to recover the bankrupt debts are stayed, and the property of the bankrupt, whether in or outside Kenya, vests in the official receiver. Section 48. However, following an application by a creditor or other person interested in the bankruptcy, the court may allow proceedings that had already begun before the bankruptcy commenced to continue on the conditions by the court. Official receiver to establish a notice advertising the bankruptcy order. Section 48. The official receiver shall publish a notice advertising the order within 30 days after the date of bankruptcy order, and the order shall be published once in the Gazette and a newspaper. Okay, why the reason? What is the rationale for notifying, for publishing this orders? Because is to let the creditors know anyone who is interested in the debtors cannot recover anymore. Remember, because the effect is all proceedings to recover the bankruptcy debts are stayed, so you cannot recover your debts once a bankruptcy order is given. Okay, now the official receiver not to publish a notice advertising where in section 48 the bankrupt has appealed against the order or has applied for its annulment. Official receiver to serve notice on bankrupt within 30 days after receiving a bankruptcy order, and the notice shall state a bankruptcy order has been made. Require the bankrupt to lodge with the official receiver a statement setting out the bankrupt's financial position. Specify a deadline for lodging the statement with the official receiver. Bankrupt to lodge statement of financial position within 14 days after being served with notice. Section 50. The bankrupt shall lodge with official receiver statement of the bankrupt's financial position, setting out particulars of the bankrupt's assets, bankrupt's debts and liabilities, names, residence and occupation of bankrupt's creditors, securities held by the bankrupt creditors, the dates when the securities were given, such other information. Now, Section 50, failure to lodge with the official receiver statement of financial position is an offense, and on conviction liable to a fine not exceeding 1 million or imprisonment for not more than 2 years, or both. Official receiver to convene first meeting of creditors. Section 52. The official receiver shall convene the first meeting of the bankrupt creditors within 30 days after the statement of bankrupt financial position is lodged. The official receiver shall convene the meeting by giving notice advertising time and date and place of meeting to the bankrupt, each creditor, and any other creditors known to the bankruptcy trustee. Okay, so this is the process post declaration of bankruptcy, and how will the official receiver come in? He will come in when the registrar of the court notifies him and gives him the court order that a bankruptcy order has been given in respect of someone. Then he will publish the said order in Gazette and newspaper and require the bankrupt to provide his statement of financial position and showing the creditor, and he will convene the meeting. Okay, he will convene the meeting of the creditors and give notice within 30 days, and that notice will also be given to the bankrupt. Excuse me. And any other creditors. Remember, I forgot this. The bankruptcy trustee is nominated by the official receiver after he is notified, okay, of the order. This bankruptcy trustee can be the official receiver himself or an authorized insolvency practitioner, okay. Now, so what happens next after the meeting is convened? Yeah, so all this, the notice for the meeting is published in the newspapers and any other publications. The documents to be sent with notice of meeting include a summary of bankrupt statement of assets and liabilities and extras from and the bankrupt explanation of causes of bankruptcy and any comment on the bankruptcy. Okay, so now the role of creditors at creditors meetings, section 58. They will attend the meetings, they will submit proofs of the debts they have against the debtor and against the bankrupt and examine the bankrupt at those meetings. So they will ask questions, they will attend the meetings and submit proofs. A creditor may not begin or continue an execution process after the official receiver has published an advertisement notifying the bankruptcy and has given notice of bankruptcy. That is what I said. The rationale for giving notice is first and foremost to let anyone know that stop whatever you are doing to recover because a bankruptcy order has been placed. And that is why in the movies sometimes you see that someone is trying to apply for bankruptcy order where he is unable to pay his debts. It's a way for him to be relieved of the actions against him, okay, by the creditors as they try to recover their debts, maybe by attaching his property or going to court for execution orders, you know. So that is what happens. Is the effect of bankruptcy order. It stays any effort to recover property, sorry, the debts. Um, if a bankrupt dies, so remember the official receiver has to serve notice within 30 days on the bankrupt after an order of bankruptcy has been made against him. Mm, now, now the okay. So what happens now is this, and also the official receiver shall publish the notice of bankruptcy order within a month, that is 30 days after the date of bankruptcy order. Okay, so it's 30/30. Now, now, if the bankrupt dies after being adjudged bankrupt, the order continues as if he was still alive. Limitations of bankrupt. All property acquired by a bankrupt during bankruptcy vests in bankruptcy trustee, who we said can be an insolvency practitioner or the official receiver himself. Okay, let me check who is the official receiver. Oh, his name is Mark Kaguru. Mark Kaguru. So Mark Kaguru is the official receiver. Okay, now okay, what else? Now, limitations of a bankrupt. All property acquired by a bankrupt during bankruptcy vests in the bankruptcy trustee or in or outside Kenya vests in the bankruptcy trustee. And the powers in respect of that property vest in the bankruptcy trustee. So this vestation or whatever it's called lasts until the bankrupt is discharged. Okay, the property held in trust by bankrupt for another person vests in the bankruptcy trustee. So if the bankrupt was a trustee himself, okay, holding property on behalf of another for the benefit of someone else, then that property also vests in the bankruptcy trustee. Such property who shall assume control of the property and deal with it for the benefit of the beneficiaries of the trust. So he will deal with it for the benefit of the trust, the beneficiaries. Allow for the undischarged bankrupt prohibited from entering business. An undischarged bankrupt is prohibited from entering the business. Section okay, shall not without the consent of the bankruptcy trustee enter into or carry on or take part in management or control of any business. Be employed by a relative of the bankrupt. Be employed by a company, trust, trustee, or incorporated body that is owned, managed, or controlled by a relative of the bankrupt. So a bankrupt cannot be employed by a relative, cannot be made a trustee, cannot be employed by a company, owned, managed, or controlled by a relative, cannot carry on management of any business or enter or take part in the management and control of any business. This is because without the leave of the court, the consent of the court or the bankruptcy trustee. This is because obviously the bankruptcy order is restrictive overall. That is the nature of the bankruptcy order. It's restrictive until that person is discharged. They cannot carry on business. Okay. They cannot be employed. Cannot take control of a business or management of a business. Bankrupt who contravenes subsection 1 commits an offence and on conviction is liable to a fine not exceeding 500,000 shillings or imprisonment for a term not exceeding 2 years or both. Restrictions on bankrupt dealing with property. Section 157. A bankrupt cannot give a release or discharge in relation to a property. So you cannot release or discharge property, you cannot be employed, cannot carry business, you cannot enter into business, you cannot manage or control business. Now, discharge of bankrupt from bankruptcy. So, time is going. Now, automatic discharge of bankrupt. 3 years after bankrupt lodges statement of financial position. Section 254. A bankrupt is automatically discharged from bankruptcy 3 years after the bankrupt lodged a statement of the bankrupt financial position. Remember when when the judicial receiver sends a notice to the bankrupt to issue their financial statement of financial position. So 3 years after that, he is automatically discharged. A bankrupt may, however, apply to be discharged earlier. So there is a timeline of 3 years. And a bankrupt is not automatically discharged if the bankruptcy trustee or creditor has objected under Section 256 and the objection has not been withdrawn by the end of the 3-year period. A bankrupt has to be publicly examined in accordance with Section 180. And the bankrupt is undischarged from an earlier bankruptcy. Okay, effect of automatic discharge. Section 255. The automatic discharge of the bankrupt has the same effect as if the court made an order for the bankrupt discharge. Okay. Now, bankrupt may apply for early discharge under Section 258 for an order of discharge. A bankrupt may have applied to be discharged earlier, and the bankrupt may not make a new application before elapse of a time set by the court if the court has previously refused an application. Now, power of the court to grant or refuse a discharge. Section 262, and hearing an application for early discharge made by a bankrupt under Section 258, or the holding of a public examination of the bankrupt under Section 259. Okay, the court may immediately discharge the bankrupt. Discharge the bankrupt on conditions. Discharge the bankrupt but suspend the order for a specified period. Discharge the bankrupt with or without conditions at a specified future date. Refuse to make an order of discharge in which the court may specify early date when the bankrupt may reapply for discharge. So it can refuse and it can grant with or without conditions. Okay. Now an adjudication order. Yeah, so it's like an adjudication order is like a bankruptcy order. It has the same effect on the property of the bankrupt, which is vested in the trustee. Okay, this is done so as to protect the property for the benefit of the debtor's creditors. The trustee will collect the same and distribute it. Furthermore, it imposes certain legal liabilities. Among other things, the debtor is prohibited from obtaining credit of more than 200 shillings from any person, must not engage in any trade other than the name under which he was adjudicated bankrupt without disclosing, cannot act as a director of a company without leave of court, cannot be elected a member of parliament, cannot act as a receiver or manager of the property of a company, except by appointment of the court. So alternatives to bankruptcy, natural persons. So remember we had mentioned earlier what are the other options apart from bankruptcy, and we had mentioned them, but we didn't get into details. The voluntary arrangement, proposal to creditors, payment in installment, and the no asset procedure. So alternatives are the ones I've mentioned. A debtor who is insolvent may, as an alternative, enter into a voluntary arrangement, make a proposal, and pay creditors in installments. Yeah, and enter the no asset procedure. Okay, and here it hasn't explained also. So I don't know. Looking at it now, it's gonna be just so. Oh, I'm so. Let's just see. You know what? Let's just forget about it. Liquidation of companies. Liquidation is the orderly realization of a company's assets so as to pay its debts. Liquidation is different from winding up, which is breaking apart the company and sharing of spoils between creditors, and whatever remains is given to members. A company can continue business after liquidation if the realization of the assets pays all debts and an extra remains. The process under the liquidation is asset realization, followed by decision of whether to dissolve or continue trading. Grounds for liquidation: failure to comply with provisions of returns and reporting under the Act and any other breaches of the Act. Now, now, liquidation of companies. This is by the application of these people. Now I wonder, isn't it the same as what we had first seen, the cases of mm, when we were looking at insolvency? Okay, so now liquidation can begin either by okay. So it can be done, started either by resolution of members, resolution of contributors, or creditors' resolution. Due notice of the resolution to liquidate must be issued to all members, contributors, and creditors of the company. Application is made to High Court, which has jurisdiction to hear dissolution of companies. It's in the prescribed format under the High Court company rules. Let's just look at the company rules, okay? Rules of court under section 10. So let me just look. Okay, I'm not seeing these roles they're talking about. I'm not seeing them. Let's just move on. Now, members voluntary liquidation. Okay, so we say that the process of liquidation is excuse me. Now, the process of liquidation is by resolution of members or contributors or creditors. The due notice of resolution must be issued to all members, contributors, and creditors, and it's made by an application to the High Court. Members voluntary liquidation. Members voluntary liquidation procedure, section 3991. Uh, yeah, so section 399 of the Insolvency Act says that members voluntary liquidation, the company in general meeting shall appoint one or more liquidators. This must be an authorized insolvency practitioner for the purpose of liquidating the company's affairs and distributing its assets. In a general meeting, section 399, subsection 2, on the appointment of a liquidator, all the powers of the director cease, except insofar as the company in general meeting or the liquidator sanctions their continuance. Members voluntary liquidation grounds, a company is formed for a specific purpose, which purpose has since been achieved. A company is formed for a specific duration and the duration has since lapsed. Okay. Alright, so the voluntary liquidation grounds is when the purpose for which the company was formed has been achieved and a company is formed for a specific time and that time has lapsed. So that is the one under section 399 of the Insolvency Act, that the purpose and time. Okay. Now members voluntary liquidation Members cannot voluntarily liquidate a company if it is unable to pay its debts. So remember that members cannot voluntarily liquidate a company if it is unable to pay its debts. Instead, they are to inform the creditors, who must then agree to commence a voluntary creditors liquidation. So this one is limited, where the company cannot pay its debts, the members cannot initiate voluntary liquidation. It's the creditors who are to be informed, who must then agree to commence a voluntary creditors liquidation. All right. Creditors voluntary liquidation. The creditors voluntary liquidation process, section 406. Okay, so under section 406, they are saying, just a minute. Okay, so where were we now? So members cannot initiate voluntary liquidation where it's unable to pay its debts, and instead they are to inform creditors who must then agree to commence a voluntary creditors liquidation. So creditors voluntary liquidation process under Section 406 of the Insolvency Act, a company that is in the course of liquidation shall convene the first meeting of creditors within 14 days of the notice for voluntary creditors liquidation. Okay. Send the notices of the creditors meeting to the creditors not less than 7 days before the day on which that meeting is to be held. Okay. So there is a notice given to the creditors to convene first meeting, okay, within 14 days, okay. The first meeting is held within 14 days of the notice, okay. Now, send the notice of creditors meeting to the creditors not less than 7 days before the day on which that meeting is to be held, okay. Ensure that notice of the creditors meeting is published once both in the Gazette and 2 newspapers of circulation within the area where the company has its principal place of business. So it will ensure that the notice of creditors meeting is published in the Gazette and 2 newspapers. The directors of the company shall prepare a statement setting out financial position of the company's assets, debts, and liabilities, and lay that statement before the creditors meeting under Section 406, and will appoint one of their members to preside at that meeting. Okay, so the whole business of not being able to pay your debts takes away from you the ability to initiate, because as a director you are responsible for running the company, and if at some point the company fails to pay its debts, your management is in question. So why else would you be trusted with the liquidation proceedings? The creditors are the ones who will suffer losses if their debts are not paid, okay, if they do not secure payment of their debt. So what happens is the creditors are to be informed, who then will agree to commence the voluntary creditors liquidation, not the directors. The directors will simply prepare a statement setting out the financial position, and also will send the notice of creditors meeting to creditors not less than 7 days. Or the decision to proceed with liquidation is by creditors, and it is initiated by creditors. And the directors prepare a statement setting out the financial position during the meeting, and lay that statement before them, and appoint one of their member to preside at that meeting. Creditors voluntary liquidation, appointment of a liquidator. Section 408, the creditors and the company at their respective meeting may nominate any unauthorized insolvency practitioner, okay, to be liquidator for the purpose of liquidating the company's affairs and distributing its assets, okay. So that is what happens. Okay. Now, the creditors and the company may nominate an authorized insolvency practitioner to be liquidator. Okay. The liquidator is the insolvency practitioner nominated by the creditors in default of which it is the insolvency practitioner nominated by the company. Effect of appointment on the powers of directors. All the powers of directors cease on the appointment of a liquidator. Now it is to be understood that the directors management is questioned big time when the company cannot pay its debts to its creditors. The creditors take over, they make the decision to proceed for liquidation. They also convene the first meeting within 14 days of their decision. Then they will also appoint a liquidator who will kind of rob the directors of their powers. So it's like the directors are not trusted anymore. The liquidator steps in because the creditors would rather appoint him and trust him with the distribution of the assets. Liquidation by the court, appointment or removal of liquidator by the court. The court may appoint a liquidator if for any reason there is no liquidator or the liquidator is unable to act. The court may, on cause shown, remove a liquidator and appoint another one. Only an authorized insolvency practitioner is eligible for appointment under this section. Now, section 417, within 7 days after being appointed as liquidator, the liquidator shall publish a notice of the liquidator's appointment. Persons who may apply to court for liquidation of a company, section 425, an application to court for liquidation may be made by any or all the following: the company or its directors. So the company or its directors, a creditor or creditors, okay, including any contingent or prospective creditor, a contributory or contributories of the company, a professional liquidator, or an administrator of the company. If the company is in voluntary liquidation, the liquidator. Okay. Add orders which the High Court can make in application for liquidation. On the hearing of a liquidation application, the court may make such of the orders after considering appropriate, including an order dismissing the application, an order adjourning the hearing, an interim liquidation, or any order. Now, the court can refuse orders for liquidation when it is satisfied that there are alternative remedies like voluntary arrangement and administration. The application does not comply with the Act. In Nakuma's Holdings Limited, the court determined that the company was clearly unable to pay its debts. However, the firm had not demonstrated to the necessary standard that an administration order was fairly likely to achieve the purpose due to the possibility that the degree of indebtedness was beyond repair. Further, there had been a lack of honesty on the side of the firm that was designed to solely benefit the company, despite the fact that, according to Section 522 of the Act, administration as a procedure ranks both the company and creditors on equal footing. In a rescue, but the administration application was refused. Since the filing of the liquidation application, the corporation had contacted some creditors independently. It also closed several of its commercial locations. Now, effect of a court liquidation order. The official receiver must notify the registrar to enter into the register the liquidation order against the name of the company. Stay it will have under liquidation. Stay of all proceedings against or by the company unless with leave of court. Management and control passes to liquidator. Directors' powers are suspended. No transfer of dealing in the property of the company is valid except with the sanction of the liquidator. Company under liquidation does not hold general meeting unless convened by the liquidator. No orders for attachment or recovery of debt can be made against the company without the approval of courts. The official receiver established by the Act under the Office of the Attorney General for administrative oversight of a liquidation and administration of companies in distress. Now, the official receiver established by the Act under the Office of the Attorney General for administrative oversight of a liquidation administrative of companies in distress. The roles of the official receiver include to act as liquidator for any company where no liquidator is appointed or vacancy arises due to resignation, death, or incapacity of the appointed liquidator. Now, convene the first meeting of creditors where the court orders and there is no liquidator. Propose for appointment of a liquidator where members of companies cannot agree. File in court upon investigation his report on what he considered to be causes of failure of company. Receive regular updates of liquidation from liquidators. Duties of liquidator is trace and secure company assets. Convene first meeting of creditors where one has not already been held. Alafu they take over control and management of company. With dispatch means in a quick and efficient way. With dispatch. This was in one of the questions in professional ethics. Quick and efficient. Okay, so they will control and manage the company, prepare regular updates, to official receiver and court. If more than 1 year lapses since commencement, the liquidator must convene a general meeting of members to update on progress of liquidation and provide reasons for extension, prepare a report on reasons of failure of company, realize assets of company. Okay. Make a distribution of the realized assets to creditors. File a final report when, in his opinion, the liquidation comes to an end, when there are no more assets to be realized. The liquidator has no obligation to keep the business running. His purpose is to realize assets and pay off creditors. Okay, bringing business to a close. Powers of liquidators, section 443, 446. Convene a meeting of creditors or members where necessary. Require the production of company records, make any inquiry or conduct any investigation. He can call on creditors to give information, transfer, assign, sell, alienate, or otherwise deal with the assets of company, enter into contract on behalf of company and terminate any contract, including terminate contract of employment or of director, direct any director to exercise any powers, enter into any compromise or arrangement with any creditor to discharge debt, institute and defend suits on behalf of company. So the liquidator can also sue and defend on behalf of company. Now, all powers are subject to the oversight and control of the court. Any person entitled to a liquidation order can apply to court where the liquidator applies his powers capriciously or illegally. Appointment and powers of a provisional liquidator. Section 437. The court may appoint a provisional liquidator either on or after or at any time before making of a liquidation order in respect of a company. Section 437. Only the official receiver or an authorized insolvency practitioner is eligible for appointment as a provisional liquidator. Appointment and powers of a provisional liquidator. Now, provisional liquidator performs such functions and exercise as the court may specify. Powers of court in liquidation: making a liquidation order, making any such orders deemed fit for proper liquidation, injunctions, conservatory, appointment of a liquidator on recommendation of official receiver where creditors and companies are unable to agree, receive reports of liquidator and make any orders required, make order on application of liquidator for production of any record borne by any person which may assist in liquidation, impose sanctions for the offences related to liquidation. Persons obligated to contribute to company assets during liquidation. Now, the persons obligated to contribute to company assets during liquidation: current members and contributories, liable to contribute any unpaid capital due from them, current guarantors, past members and contributories, subject to the following conditions. So any unpaid share capital will be given by the members. Current guarantors, any guarantors who have guaranteed upon liquidation, past members and contributories, subject to following conditions. The past members. The debt for purpose of liquidation must have been incurred when they were still members. They must have not ceased to be members for a period of not less than 12 months before the liquidation. Any person that the court may find liable or as a cause of the failure of the company. Yeah. The liquidator has recourse to all assets of the company except secured assets and a floating debenture which has become fixed. Secured assets for which the creditor has already exercised his right under the instrument. Liquidation of unregistered companies. Unregistered companies include cooperative societies, building societies, limited liability partnership within meaning of Insolvency Act includes the corporation under the Sectional Properties Act. Now, a company cannot be liquidated voluntarily and only court can order liquidation. Liquidation can be ordered when a company is notified of payment of debt and it fails to pay or secure the debt. Let me just look at this properly. Now, um, okay, a company cannot be liquidated voluntarily and only court can order liquidation can be ordered when a company is notified of payment of debt and it fails to pay or secure within 21 days. When judgment is entered against the company and the company does not settle within 21 days, where foreign companies can be liquidated, persons liable to contribute to company assets in the event of liquidations, no proceedings may be begun or continued against a contributory for days of company. Court has power to stay proceedings against a contributory of unregistered company. No legal proceedings may begin or continue unless approved by court. Administration of insolvent companies. Now remember in High Plast, in High Plast Limited case, the company was granted an administration order, and in Nakumat Holdings, it wasn't because the object of the order under section 52 would not have been fulfilled because the state of indebtedness was beyond repair. So, administration is a procedure used while reorganizing a company or the realization of its assets under the protection of a statutory moratorium. And administration is the placement of a company under distress to an independent qualified expert. for the purpose of reviving the company. The objective of administration is not to realize assets, but to keep the company as a going concern for the benefits of creditors and members. Administration prevents creditors from taking action to enforce their claims against the company during the process, preventing implementation of a strategy for the company's rescue. Unlike liquidation, the company may not enter into contracts beyond certain thresholds without approval of administrator. The administrator must be notified every time members hold a general meeting. When is a company said to be under administration? Section 521 enters administration when appointment of an administrator takes effect. A company is under administration when the appointment of an administrator of the company continues to have effect and ceases to be in administration when the appointment ends. A company does not cease to be under administration only because an administrator vacates office, whether through death, removal, or resignation. Section 5, that is, an administrator is appointed by way of an administration order. He is considered as an officer of the court. Whether or not appointed by court, he is an authorized insolvency practitioner. He has a duty to perform his functions as quickly and reasonably practicable. Cannot be appointed if a company is already in liquidation. So those two cannot simultaneously coexist, either liquidation or administration. The administrator cannot also be appointed for banking institutions and insurance corporations, as these are different regimes. Duty of administrator: convene creditors meeting within 70 days, prepare proposal and send to creditors within 60 days. Can also undertake to appear before creditors committee on request subject 7 days notice. Control company asset, control affairs of company, publish notice of his appointment within 7 days, distribute properties to creditors as provided. Appointment of administrator can be appointed by the company or its directors or by debenture holder. So directors can appoint administrator or the company or debenture holder. Court can issue administrative order on application by debenture holder. Notice of intention to appoint an administrator must be given within 7 days. Must identify an administrator with his consent lodged in court, accompanied with a statutory declaration specifying that the company is unable to pay its debt, that the company is not in liquidation, and that the appointment of an administrator is not prevented by a moratorium. Once prepared, the notice is to be lodged in court within 14 days. This notice is the application for appointment of an administrator. Appointment of administrator by a company or its directors. Persons who can apply to court for an administration order include an application to the court for administration order in respect of a company may be made only by the company, the directors, one or more creditors, a combination of company directors and creditors, or any other person. By the rules, effect of administration application: any pending application for liquidation is suspended when it's ongoing. Creditors can only realize security with court permission. Proceedings against company are subject to court approval. Grounds for court consideration before making administration order: when the company's net assets are more than its liabilities. So the court will look at whether the company's assets are more than liabilities. In such case, okay, so this company has reasonable prospects of paying its debts even if they demand it today. When the company reasons for failure is other than financial reasons, when there has been fundamental shift in the business of company requiring someone with expertise to restructure the company. A company with little history of financial default will be candidate for administration. So the administration order is likely to be granted to a company which did not anticipate the failure to pay debts, maybe like the one in Rehai Plast Limited. It was affected simply by the government's ban of plastic, which it couldn't have anticipated. Okay, so that was a huge shift and it affected the business of the company. So it was granted an administration order given that consideration. Okay, an administration order is an order appointing a person as the administrator of a company and providing for administration of the company by that person. It is issued if court is satisfied that company is or is likely to become unable to pay debts, and the administration order is reasonably likely to achieve objective of administration, which is to keep the company as a going concern. Through an interim admin order, the court can restrict directors' powers or reserve discretion of court. The court can treat application for administration as liquidation application and make such orders under its effect of administration order. All proceedings against the company for recovery of any debt or decree is stayed. Okay, so all proceedings against the company for recovery of debt or decree is stayed. No suit shall be instituted for against the company without leave of court and approval of administrator. The company continues to operate, save that the directors might not exercise powers. Okay. Now, every company must indicate in their own documents and correspondence under administration. Company voluntary arrangements provided under the Insolvency Act in relation to a company means a composition or scheme of arrangement that has effect as provided by Section 630. A director's proposal with or without modifications takes effect as a voluntary arrangement by the company when it is approved by an order of the court made under Section 629, company voluntary arrangement binds every member of company who is entitled to vote at the meeting. Would have entitled to vote had they received a notice. Okay. Every person, including secured creditor and preferential creditor, who is entitled to vote at the meeting. Okay. Whether present or represented or not. Or would have been so entitled if the person had received notice. Procedure: directors make proposals to company and to directors for voluntary arrangement. The directors of a company may make proposals to the company and to its creditors for a voluntary arrangement. Administrator, where companies and administration may also make a proposal for voluntary arrangement, and the liquidator, where companies and the liquidation may also make a proposal for voluntary arrangement. The company enters into a composition satisfaction of its debt or a scheme for arranging its financial affairs. The director shall provide for appointment of a person to supervise implementation of voluntary arrangement. Only an authorized insolvency practitioner may be appointed to supervise a voluntary arrangement. Now, Okay, so now the person who will be in charge is the provisional supervisor, unlike the administrator in administration and the liquidator in liquidation. He will convene meetings of company and company's creditors to consider the proposal made by the directors. Okay. He can call creditors to the meeting. Directors to notify provisional or supervisor on any modifications of the code. Okay. All right. Now, on any directors to notify provisional supervisor on any modification of proposal. Now, purpose of the meeting. The main purpose is to decide whether to approve the proposal or that proposal with modifications. To the director's proposal may be approved only if the company consents to it. A modification to the director's proposal may provide for replacement of the provisional supervisor by another authorized insolvency practitioner. Supervisor of the proposal takes effect as a voluntary arrangement. Conduct of meetings. At the beginning of a creditors' meeting, the meeting shall elect one of their number to be chairperson of the meeting. The creditors, So, the first meeting of creditors shall divide the meeting into 3 groups. First group, second, third group. Uh, mm, so you can challenge the voluntary arrangement by going to court, and this person's any person who was entitled to vote at the meeting, a person who would have been so entitled, the provisional supervisor or the liquidator administrator can challenge in court. Grounds for challenging in court decisions relating to approved voluntary arrangement may be made either both of the following grounds: that a voluntary arrangement approved under Section 629 detrimentally affects the interests of a creditor, member, or contributory of the company. Okay. A material irregularities has occurred. So those are grounds for challenging the the arrangement. Time within which an application may be made. An application is to be made within 30 days. Makes a report to the court. Now, decision of the court in an application challenging approved arrangement can revoke or suspend it, directing the supervisor to convene further meetings to consider a revised proposal. The implementation of approved, who is responsible for implementing arrangement is the supervisor becomes responsible, and a company's creditors or any other person who is dissatisfied with an act, omission or decision of supervisor may make an application to court, which court may make an order quashing or modifying an act, omission, giving supervisor directions confirming the act. Supervisor may make an application to the court, which court may make orders giving directions in relation to any particular matter arising under the voluntary arrangement. The supervisor may also make an application to the court for liquidation of the company or for an administrator to be appointed in relation to the company. The court may make an order appointing supervisor to replace all other supervisors. Moratorium on debt payment when companies directors propose voluntary arrangement. What is a moratorium? It means that has taken effect under section 655 and has not ended. Companies eligible for moratorium is the postponement of payment of debts. 645. A moratorium means a moratorium that has taken effect under 645. Why would you define moratorium if you don't want to define it? Okay. So a moratorium does not apply where the company is in administration or is in liquidation or has approved a voluntary arrangement. Okay. Mm, the directors are the ones who prepare the documents, setting out the terms of the proposal and statement of financial position of company, and appoint provisional supervisor. They will submit the proposal to the supervisor, and so they bring a statement of his opinion. The supervisor's opinion should indicate whether or not the proposal has a reasonable prospect of being approved and they have sufficient funds available during proposed moratorium. Meetings of the company should be convened. They will lodge with the court the following documents: the proposal and statement, the statement of that it is eligible for moratorium, and a statement from provisional supervisor showing consent of his position. A statement of opinion regarding prospects of approval and implementation, availability of funds, whether to convene meetings. It takes effect when the document is lodged with the court. When directors, the directors of the company shall immediately give notice of that fact. Failure to give notice is an offense when the moratorium takes effect. Now, the effect of a moratorium on creditors. A moratorium has the following effects: an application for liquidation for liquidation the company may not be made. Application for company may only be convened. A meeting of company may only be convened with the consent of the supervisor and approval of court. A resolution for liquidation has no effect. The court may not make an order for liquidation of company. An administrator may not be made. An administrator of company may not be appointed. And landlord or other person may exercise a right of forfeiture in relation to promises laid to company. Steps may be taken to enforce any security over company's property or repossessed goods. Okay. Now that concludes the law of insolvency. We have looked at bankruptcy. We have looked at so that is that. My goodness. There is the partnerships. Dinka, 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 dinka. Okay, now there's three topics, but let me just go and quickly get ready. Alright, just get ready first. Then we look at partnerships. Bye. I hope I have enough time.